appear, but it's like
Without prejudice.
Yes.
McDonald. What's going on with McDonald?
Or you mean Mr. McConnell? Your Honor?
McConnell, yes, thank you. What's going on with McConnell?
Your Honor, the victim is here and present. So I would defer to Ms. Donnelly.
There was no offer. It was pleaded as charged with restitution. So at this time, we would be requesting our jury trial.
Okay, your trial scheduled for April 19th at 8 o'clock in the morning. Do you have a question today, sir?
I don't.
Okay, we'll see you we'll see you on April 19th. We'll get you a copy of your notice to appear. Okay, sir?
Thank you.
Jessica Wilson.
Yes, Jessica Wilson was allowed to appear by Zoom, and she was here.
Okay, are we continuing to trial on this?
Yes, Your Honor. It is my intention, yes, to take this to trial with the offer was it?
It was to plead to one of the dog at large counts, pay restitution in the amount of $859.90 to the victim, and I would dismiss the remaining counts.
Oh, so we're declining the offer, continuing to trial, correct?
Yes, Your Honor.
Okay. Ms. Wilson, your trial is gonna be set for April 5th at 8 o'clock in the morning,
I
okay?
could adjust, Your Honor.
I'm sorry?
If I could just request something of the court. I did speak to the victims in this matter. They were present on Zoom. The victim is,
They're still in the waiting room, I believe.
they do reside in Florida for part of the year. They are planning on coming back until June. I was just wondering if the court would allow it to be set out further so they don't have to come back previous to their return.
On the record in the matter of the people of the state of Michigan versus Jessica Wilson, file number 21-03459 SM. Council appearance.
Good morning, Your Honor. Andrea Lacey appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Jessica Wilson, who is appearing by Zoom.
It was a date that was set for final pretrial. There was an offer on the record stated the last pretrial for the defendant to plead guilty to one count of the dog at large and pay restitution. The offer's being declined today. That's correct, Ms. Donnelly.
Yes, Your Honor.
So we're going to continue to trial. Trial is currently scheduled for April 5th at 8 o'clock in the morning. Prosecution was making a motion to extend the time so that your client can be here. Is that what the question?
Correct, Your Honor. They do already have return plans for the beginning of June.
Ms. Donnelly.
Yes, Your Honor. We would like to have our trial as soon as possible. I have witnesses that I would like to have appear, and the longer this case sits, the bigger the chances that they can't appear either. Also, Ms. Wilson was arraigned on this on January 13th, so she has a right to a trial within 180 days. So I would at least hope that this court would not put it past June 13th or the 6-month date after her arraignment, Your Honor. But we would object to that. This is a case that the complaining witness is pushing for. So if she that would have been the reasonable expectation that she would appear in court when it was time to do so, and not at her discretion, Your Honor. Thank you.
Your Honor, if I may respond just briefly. My complaining witness worked with me to come up with this plea bargain that we believe is more than generous for Ms. Wilson, considering the circumstances and the damage to the victim's dog. In 180 days from January 13th would be July 12th. So even a trial date in June would still be within that 180 days.
I'm not inclined to extend this at your client's or your victim's convenience. That's not how we operate here as it relates to our court docket. You know, we have a pretty extensive trial docket. I'm happy to adjourn it because I can recognize that if she's gonna try to purchase a ticket to get here next week, with the current price rates of these tickets, it could be astronomical. But it'll probably be the earliest available date in May. I'm not inclined to push it till June, because anything can happen. Right?
Fair, and that date, Your Honor, then will be certain.
The date, we can make the date certain. I don't, what do we have going on in May?
Well, we can do May 17th, and that will be the only thing right now.
Okay, we'll set it for May 17th. That'll be a date certain for this trial. We'll make sure we don't set any other trials on that date, okay?
Thank you.
Any additional matters for the record?
No for the fence, Your Honor.
Nothing from the people.
Thank you. Ms. Wilson, we'll see you on May 17th, okay? She was muted, but I assume she didn't have a question. Ms. Wilson, you're muted, so I couldn't hear you. Good morning, Ms. Neal. Mrs. Neal, sorry.
Good morning, Your Honor.
You're here with Marquita Milton, correct?
Yes, that is correct.
Did you need to speak to her privately, or are you ready to proceed on the sentence?
We are ready to proceed. Thank you.
Ms. Milton, you can hear me clearly?
Yes.
Okay, you're not driving, are you?
No, ma'am.
Okay, thank you. On the record in the matter of the people of the state of Michigan versus Marquita Milton, the file number 21-03178 SD. Can I have your appearance, counsel?
Good morning, Your Honor. Yana Neal, appearing on behalf of the defendant, Marquita Milton, who was present via Zoom.
Thank you. Today was the date that was set for sentencing. I do have a pre-sentence report and recommendation. And Ms. Neal, you received a copy of that, correct?
Yes, I did. Thank you.
Did the court make any updates, corrections, or deletions at this time?
We do not have any corrections or additions to the report.
Thank you. Did you want to proceed with allocution?
Yes, thank you, Your Honor. Your Honor, Ms. Milton is a 30-year-old mother. She has had employment, consistent and good employment, excuse me, for the past 5 years. I would indicate to the court that Ms. Milton has also paid the $90 that is noted in the assessment as still being owed under the alcohol and drug assessment section. She advised me that she paid that on last Friday. I would also indicate to the court that in working and speaking with Ms. Milton, she has been, I would say, very self-reflective regarding this situation, as well as her, I guess, struggles or issues with alcohol. As the court is aware from the pre-sentence investigation report and the report attached, Ms. Milton was very cooperative with law enforcement when this matter occurred. She was also very honest as it related to her drinking prior to driving. I would also indicate to the court that although it is definitely not an excuse, that Ms. Wilson had lost a friend, and that is what precipitated her consuming alcohol. Prior to that, she had been sober for the previous 4 years. I would also indicate to the court that Ms. Milton has indicated that she is remorseful for this incident. She knows that the passing of her friend is not an excuse as it relates to drinking and driving. I think that the probably most important and introspective thing that me and Ms. Milton talked about is something that is actually included in the pre-sentence investigation report, where she indicated that I believe that once an alcoholic, I'm always going to be one, is just a day-by-day, step-by-step process. I would indicate to the court that Ms. Milton has huge family support, that she has re-engaged in her therapy services. She is absolutely capable, willing, and wants to participate in the probation and the recommended orders from the probation officer. I would also indicate to the court that again, from speaking with Ms. Milton, she seems very serious about maintaining her sobriety. She does have a minor child, and she understands the very seriousness of this incident, and understands that any future contact with the court regarding drinking and driving offenses would put her in a situation to be charged with a felony. And she absolutely does not want that, especially given her employment. And it's really her goal to maintain sobriety. We did review the recommendations. We believe that they are appropriate, and I'm confident that Ms. Milton will successfully complete probation and will maintain her sobriety. So we would ask that the court adopt the recommendations. Thank you.
Thank you. And was it your client's intention to make their own statement today? At all?
Yes, Your Honor. Thank you.
Milton, you can proceed.
I just wanted to personally apologize to you all, my family and the community for this incident I caused. Although I was going through a tough time, there still was no excuse. As I struggle with this issue in the past, I know that it's something that I will always struggle with. But with great thanks to my support system, I will continue to diligently work toward my sobriety journey in hopes of moving forward with a sober, safe life. I definitely owe that to myself, my child, my family, and the community.
Thank you. The court had an opportunity to review the pre-sentence report and recommendation. I also have a copy of your prior criminal history, which is limited to this incident and your previous OWI. I think that you're the ideal candidate for a short term of probation. You did score moderate low risk, and that you're already engaging in some outpatient treatment. You've made a determination for yourself that you need to continue to live a sober life, and again, as indicated by your attorney, to take it as a day-by-day, step-by-step process. And hopefully, because you are self-determined and not being made to get to this place by the court, that you will have a future of sobriety and success. So the court is going to adopt the recommendation of probation. I'll place you on a term of 6 months probation. While on probation, there is a $30 per month oversight fee that you would be responsible for. While on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess alcohol, marijuana, or any other controlled substance unless you have a valid prescription, okay?
Yes, Your Honor.
You will be required to submit to random preliminary breath tests and or urinalysis. You would be responsible for the cost associated with that, okay?
Yes, Your Honor.
In order that you continue your 12-step meetings and outpatient treatments. At a minimum of 2 times per week.
Yes, Your Honor.
Need to provide verification of the 12-step program participation and outpatient participation to your probation officer, okay?
Okay.
Should maintain your employment while you're on probation. Do you have any questions regarding your probation status?
No, Your Honor.
As to fines and costs, there's a $75 crime victim rights fee that will be assessed, $50 state minimum cost that will be assessed. Probation in the amount of 6 months, $180. You have a $562.62 OWI cost recovery fee owed to the Lansing Police Department. And you've already paid the $90 assessment, so. Gonna waive
Yes.
any discretionary fines and costs. Total fines and costs will be $867.62. You will have the opportunity to make monthly payments on that, okay?
Yes, Your Honor.
Okay. Do you have any questions about your fines and costs?
No, Your Honor.
Probation advice and rights here says you have the right to request a hearing for early discharge from probation. Once you have completed half the original term ordered by the judge, you must file a motion for early termination of probation with the court. You cannot request a hearing for early discharge until all rehabilitative requirements have been met and there have been no probation violations within the 90 days preceding your request. You understand those rights so far?
Yes, Your Honor.
You have the right to hire or retain an attorney to represent you if a hearing is necessary for that request, but you do not have a right to court-appointed counsel. Just for your information, I've not held any hearings on this thus far. I've just reviewed and granted based on the written motion, which you can get that from the probation department.
Okay.
If you are on probation for domestic violence, stalking, criminal sex crime, human traffic violations, or an offense where the defense was asserted of guilty but mentally ill, you are not eligible for early discharge from probation. Do you understand those rights, ma'am?
Yes, Your Honor.
Do you have any questions regarding those rights?
No, Your Honor.
Okay. Your phone number still is the number that ends in 1024?
Yes, Your Honor.
Okay, someone from probation will be in touch with you to go over the judgment of sentence so that you can review and sign it, okay, ma'am?
Yes, ma'am.
Okay, any additional matters for the record today, counsel?
Your Honor, I do just have one, and I'm bringing it up because I don't want Ms. Milton to have any issues, especially if she becomes eligible for early release, is the prosecutor cost recovery. I don't believe the court mentioned that.
That is correct. It is $120 prosecutor cost recovery that will be assessed. Thank you, Mrs. Neal.
You're welcome.
Okay.
So that will change your balance. So $987.60.
Okay.
Okay.
Yes.
Okay. Any additional matters for the record?
No, Your Honor. Thank you.
Thank you. You're all set, Ms. Milton. Good luck.
Thank you, Your Honor.
Thank you, Your Honor. Have a good day.
Thank you. Have a good one. Thank you. Okay. Paige Yeomans. So on the record in the matter of the people of the state of Michigan versus Paige Lynn Yeomans, file number 22-00469 SM, council appearance.
Morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Good morning, Your Honor. James Keatley, Assistant Public Defender, appearing on behalf of Paige Yeomans, who is present in the courtroom to my right.
Thank you. Today's the date that was set. For final pre-trial. How are we proceeding on this?
Your Honor, I asked that this be held on the record because I was able to speak to the victim in this matter, Kelsey Ellis, last week on the 17th. She told me that she wanted the case to go forward. However, she was supposed to be admitted to the hospital that day to give birth over the next few days. I asked her if she if she remembered, if she could potentially just give me a call and let me know if that had happened. I have not heard from her, but when I talked to her, I could hear a lot of personnel in the background. It does sound like she was already potentially at the hospital. So I'm asking that this case be adjourned 30 days so that she can appear. And I would also ask that she be allowed to appear by Zoom if the court is so inclined, just because if she did give birth over the weekend, it would be very recent and would probably be hard for her to get down here with a newborn.
You said you spoke to her when?
On the 17th,
And she was supposed to be admitted this weekend to give birth?
yeah, she said she was being admitted to the hospital and would be giving birth hopefully the next few days.
Mr. Keeper.
Thank you, Your Honor. Without getting too deep into the facts of this case, Miss Yeomans and the complaining witness are related in this matter, and of course they have other relatives. Miss Yeomans knows not through personal contact or even something that would even be an alleged violation of the no contact order that the complaining witness did go to the hospital and did give birth on, I believe, the 18th. She has since been discharged. I would note that neither complaining witness is here, Your Honor. We would be asking that this matter be adjourned, or failing that, just be set for another regular final pretrial.
Okay. So Ms. Ellis is the one who just had the baby. Who's Mr. Dunn?
That is an acquaintance of both Miss Ellis and Miss Yeomans.
Okay, because of the circumstances I'm going to request we set this to a later date for a final pretrial.
We can do the final pretrial May 10th.
May 10th at 8 a.m. All parties can appear via Zoom.
Jury trial will be May 24th.
May 24. Okay, thank you.
Jury trial May 24th. Oh. Any additional matters for the record?
No, Your Honor.
No, Your Honor, thank you.
Thank you. You're all set.
Miss Dyke, are you there?
Shouldn't start her audit.
Oh, she hasn't started. Okay, perfect. Miss Dyke, are you there?
Are you there, Mom?
Yes,
Can you hear me? Okay. We got a new jury trial date. It's May 17th, and I will call you guys later this week and discuss that with you, okay?
okay,
You guys are free to go.
Say okay. Mom.
okay.
All right, thank you. You guys can log off Zoom now.
Okay, we can go on soon.
Mr. Langen? This was the one we were waiting for, correct?
Yes, and it's finally been issued.
On the record in the matter of the people of the state of Michigan versus Joseph Langen. This is the file 22-00731. Can I have your appearance, counsel?
Good morning, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Joseph Langen for the limited purposes of arraignment this morning.
Thank you. Today is the date that's set for an arraignment. Mr. Langen, I have here a felony warrant and complaint. It alleges that on December 30th, 2021, in the area of South Martin Luther King Boulevard in West Ottawa, that you did allegedly, contrary to law, commit the act in count 1 of operating while intoxicated. It alleges that you did operate a vehicle upon a highway, that being South Martin Luther King Boulevard and West Ottawa Street, while under the influence of alcoholic liquor or having an alcohol content of 0.08 grams or more per 100 milliliters of blood. That this is contrary to Michigan Compile Law 257.6251. That would be a misdemeanor with a maximum penalty being 93 days and or $100 to $500 in fines and or 360 hours of community service. Rehabilitative programs, vehicle immobilization is mandatory with a prior under MCL 257.904D, and cost of prosecution reimbursement to government for emergency response and expenses for prosecuting defendant may also be applied under MCL 769.1F. This is a third offense notice felony, making the charge a felony with them. It states here that take notice the defendant was previously convicted of operating while intoxicated on or about 11/22/2021 in the 54A District Court, and of operating while intoxicated on or about 9/3/2015 in the 64A District Court. Therefore, upon conviction, the defendant will be subject to an enhanced sentence under Michigan Compile Law 257.6259 or MCL 257.62511, and vehicle forfeiture is required under MCL 257.625N. That's a felony, maximum penalty being $500 to $5,000 in fines and either 1 to 5 years or probation with 30 days to 1 year in jail, at least 48 hours to be served consecutively, and 60 to 180 days of community service. Rehabilitative programs as well, to see MCL 257.625B5. The cost of prosecution reimbursement to the government for emergency response and expense for prosecuting defendant may be applied, and mandatory vehicle immobilization of not less than 1 year or more than 3 years may also be applied under MCL 257.904D. Mr. Langen, do you understand the charge there and the maximum penalty associated with the charge?
He's muted.
Oh, can you unmute, please, sir?
I'm sorry. Yes, Your Honor.
Thank you. You have the right to be represented by counsel. You do have Mr. Keithley here from the Public Defender's Office to represent you for the purposes of your arraignment today. You have the right to have an attorney represent you at each stage of this criminal prosecution. If you cannot afford to hire an attorney, but you're economically qualified, an attorney can be appointed to represent you at the expense of the public, okay?
Okay, yes.
I'm assuming he's requesting court appointed counsel.
Yes,
correct?
Your Honor.
Okay, Mr. Langen, you have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty, or you can stand mute. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to proceed to a preliminary examination in this matter. You have the right to have that examination within 21 days of today's date. At the time of your examination, you have the right to have the prosecution establish their burden of probable cause. They have to establish that there's sufficient probable cause that a crime was committed and sufficient probable cause to charge you with that crime. Do you understand that?
Yes.
You also have the right to proceed to trial in this matter, and you have the right to have a jury trial. At the time of your trial, you have the right to remain silent and not have silence be used against you. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to question or cross-examine any of the witnesses that the prosecution intends to call. You have the right to call your own witnesses or present evidence that you believe may further any defense to the charge. Do you understand that?
Yes, Your Honor.
Do you have any questions about those rights?
No, Your Honor.
Okay. For the purposes of his arraignment today, how would your client like to plead?
Not guilty, Your Honor.
Court will enter a plea of not guilty on your behalf. Are you still at the address at 4600 South Pennsylvania?
Yes, Your Honor.
Are you still unemployed or have you now gained employment?
I am now employed. Yes, Your Honor.
Okay, where are you employed, sir?
KPW Management.
What do you do there?
I do apartment maintenance. Maintenance tech.
Your phone number still ends in 8151?
Yes, Your Honor.
8185.
Yes, 8185. Yes.
Thank you. Okay. Probably show a bond in the amount of 500 personal recognizance. I would assume, due to the nature of the charge, we probably need to adjourn this other
That was going to be my question.
case. Okay.
I anticipate, based on my discussions with Mr. Lane, that it will likely not have to be a long adjournment. If the court would allow for us to get past the PCC date for Mr. Langen's felony file and then potentially set both matters for what I anticipate will be a sentencing at the same time in both matters.
You can do April 7th at 8:30 for the PCC.
April 7th at 8:30 for PCC.
And then you can do the exam April 14th.
Exam will be April 14th. Wait a second. Have to wait 21 days now because that's already beyond 21 days. That would be, today's the 22nd, so April 5th is his 14 days. He has to have his PCC within 14 days. Which I don't have a problem with setting it for a Tuesday. We can set his PCC for a Tuesday. I'm sorry. Sorry.
I don't know that I'm going to be the one assigned to do his case. I suspect they will, but
Yeah, we can set it for his PCC for a Tuesday and then
We can do the 29th. Well, he.
why can't we do the 5th? We're not.
Your Honor, I expect that Mr. Langen would likely be willing to waive the timeline for a preliminary examination if we'd be able to go forward with the days as currently set.
Okay. Mr. Langen,
Yes, Your Honor.
you have the constitutional right to have your preliminary examination within 14 days of today's date. As indicated previously, you also have the right to have your preliminary examination within 21 days of today's date. However, due to the nature of, well, you were supposed to be arraigned, it looks like on the 31st, which is why those dates were probably going to work. But at this time, because of it being on a Tuesday, the dates in which you would normally have those exams would be on a Tuesday, which we actually hold those on Thursdays and Fridays. You're also already being screened for possible sentence under the sobriety court. So due to those reasons, would you be willing to waive your 21 days timeline so that we can set these for a date and time for you to come and have a preliminary examination or a probable cause conference beyond the 14-day and 21-day timeline? Would you be willing to waive that 21 days?
Yes, Your Honor.
Okay, what date did you say before? April 7th, April 7th, and the preliminary exam is the 14th?
Yeah.
Both at 8:30?
Yeah.
Okay, we'll set your probable cause conference for April 7th at 8:30 in the morning. Your exam right now will be scheduled for April 14th at 8:30 in the morning, but that may be converted to a sentencing, correct?
I don't know if that date would be converted over
Okay.
to sentencing. I anticipate that we would likely get a sentencing date on or around the 7th.
Sounds good. So we will reset your sentencing in file number 19-04589 after the date of your next court date, okay?
Okay,
No, we'll reset it.
Then?
Yeah, on April 7th, we'll set it. Any additional matters for the record?
No, Your Honor, thank you.
Thank you. You're all set, Mr. Langen. We'll see you
All right,
April
thank you.
7th.
April 7th at 8:30.
That's correct.
Okay, Your Honor. Thank you.
No problem. Okay. What do we have here? What's your name, ma'am? Is that a witness?
Your Honor.
Yes.
So Ms. Hartwig is set at 9:30. She is on bench warrant status. She, I believe, a felony matter and a matter in the 54B district court. I suspect that she will not be hearing. If the court will allow, I'm gonna walk back over to my office. If she shows up over Zoom, I'll be on hand relatively promptly, but I can't guarantee I'll be there at 9:30.
No problem.
Thank you.
Okay, that's that one. We took care of all of the eights. I just did, Okay, good morning. Is it Ashley Simpson?
Yes, it is. Good morning.
Okay, good morning. Ms. Donnelly, is Ms. Simpson your client?
Yes, Your Honor, I do need a breakout room with her.
Okay, I'll put you in a private meeting room. And maybe you can counsel her on how to appear when she comes back.
Thank you, Your Honor.
No problem. name, sir?
Marcus Miller?
You have an attorney?
No.
On the record in the matters of the people of the state of Michigan versus Marcus Terrell Miller. I have 3 files here, file number J040647, J073, 4481 and J044894. Council appearances.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Thank you. And Mr. Miller, you're proceeding without an attorney, correct?
Correct.
Okay, today was the date that was set for hearings on 3 applications for motion to set aside convictions. Ms. Lacy, we do have a proof of service that was filed by the defendant stating that he did serve the AG's office and your office on the 2nd of this month. We do not have a notice from the prosecution, I'm sorry, from the AG's office at this time. Do you have any record of receipt?
So, Your Honor, I do show that we have received the application for Mr. Miller at least 2 times. Unfortunately, the most recent one is scanned into my computer, and all it is 3 pages of a proof of service. So it doesn't actually tell me anything.
I can get you copies of these.
I do have a copy of his application. I don't have anything from the Attorney General's office other than the notices saying that it was served on them. So I don't have any other information. It sounds like than what Your Honor has.
Sir, are you currently on probation? or parole?
Yeah, yes,
Okay. It's federal probation?
yes. Yes, you,
Looks like you were just sentenced to that December.
on federal base, yes, yes, you.
Unfortunately, sir, I think I'm going to adjourn your matter because I am going to wait for an opinion from the Attorney General. That's specifically because you are currently on federal probation. So they would need to opine at this point.
Just for the record, Your Honor, also, I was locked up from 2012 to 2021. Federal system, I got out and get probation.
You just got out in February.
I got out on March 15th of last year.
Okay, sounds good. And so the one that you're currently on probation, this is a new charge?
No, this is the current charge. When you do federal time, you get out and you go to a halfway house. And after you go to a halfway house, they put you on probation, serve as supervisor.
Okay. Okay, sounds good. So I'm gonna, again, put you're on probation until 2026?
Yes, yes.
Okay. So and you say you were released last March?
On March 15th, 2020. I did 6 months and a half.
Okay.
My 6 months is up, December 10th.
Oh.
Start my federal probation.
Okay, very good. So what we'll do is we'll wait to get an opinion from the Attorney General's office. I would imagine that since you served them on the 2nd, they probably just needed a little bit more time to respond. Okay, we'll get you a new date. Sean has to reset that, correct? Okay, is he here today? Okay, you can have a seat there. We're gonna go off the record. If we can get you the new date today, I'll get it for you today, okay, sir?
Back here?
Yep. Okay. Yeah, sure. we want a new date?
I have 3 motions.
Same defendant. Thank you. Are we ready, Ms. Simpson?
Yes, Your Honor.
On the record in the matters of the people of the state of Michigan versus Ashley Marie Simpson. File numbers 22-00551 and 22-00545, council appearance.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of defendant Ashley Simpson, who is appearing separately by Zoom.
Okay, today's the date that's set for pre-trials on both files. Were there offers extended on this?
Yes, Your Honor. She was given an offer to plead to one case with an agreement to pay restitution in the amount of $177.29 from both cases, and we would dismiss the other case.
Ms. Donnelly?
Yes, at this time, Your Honor, Ms. Simpson would like to take that offer.
Ms. Simpson, is that correct?
Yes, ma'am.
Okay. Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, ma'am.
Thank you. You can put your hand down. Smith, you have the right to proceed to a trial in this matter, and you have the right to have a jury trial. Ma'am, are you laying down?
No, ma'am. I'm sitting down.
Okay.
Hold on.
I
Want
just
to
have
see
a
me
concern.
better?
I want to make sure that you're taking this seriously. I did ask your attorney to give you some helpful advice about how to appear. When you appear before the court, ma'am, you want to appear showing that you take this matter seriously and that you are self-respecting, but you're also respecting the process. And so it would not have been in your best interest to appear with a bonnet on your head today. If you were coming in person, would you have appeared with the bonnet on your head?
No, ma'am. I'd have threw on one of these wigs.
Okay, well, that was what the expectation would be if you were to log into my Zoom courtroom. How would you feel if you logged in and I had a bonnet on my head today?
Unprofessional.
Thank you. That's exactly the point I'm trying to prove here.
I'm
So when
sorry.
you log into a courtroom or when you come into a courtroom, ma'am, always present yourself like someone who's self-respecting, okay?
Yes, ma'am.
Okay. So again, you have the right to proceed to a trial in this matter. You have the right to have a jury trial. At the time of your jury trial, you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand that?
Yes, ma'am.
If you want to plead guilty, you would have to give up that presumption of innocence today. Is that what you want to do?
Yes, ma'am.
Okay, so that means you're also going to be giving up your right to remain silent at trial and not have silence be used against you. You're going to give up any right that you have to cross-examine or question any witness that the prosecution intended to call to prove their case beyond a reasonable doubt. You're going to give up any right that you would have to call your own witnesses or present evidence that you believe would further any defense to the charges. Do you understand that?
Yes, ma'am.
Is anybody making any promises to you to get you to waive all of those rights and plead guilty today?
No, ma'am.
Anybody threatening you in any way to get you to waive your rights and plead guilty?
No, ma'am.
Are you currently on probation or parole?
No, ma'am.
And are you pleading guilty, ma'am, because you believe you're guilty?
Yes, ma'am.
Okay, is there any particular one that she needs to plead to, or does it matter?
It does not matter.
Okay. Ma'am, as to the charge of retail fraud in the 3rd degree and file number 22-00551, how do you plead?
I plead guilty.
Ms. Donnelly, can I have a factual basis?
Thank you, Your Honor. Ms. Simpson, on September 21st of 2021, were you at the Meijer at 6200 South Pennsylvania in the city of Lansing, Ingham County, state of Michigan?
Yes, ma'am.
And while that Meyer was open to the public, did you steal merchandise offered for sale at a price of less than $200?
Yes, ma'am.
And was that food and clothing items that you, when you went through the self-checkout, you didn't scan them?
Yes, ma'am.
All right, and the amount for September 21st, do you dispute that it was $108.90?
No, ma'am.
Okay. And then for the restitution on September 9th, you dispute that you stole merchandise from Meyer while it was open at a price of about $68.39.
Yes, ma'am.
You don't dispute it, correct? No?
Correct. I don't dispute it.
All right, Your Honor, I have no further questions.
Thank you. Any additional factual basis from the prosecution?
No, Your Honor, that's sufficient.
If the court is satisfied with the factual basis, I'm going to accept your plea. Hereby your plea to be made freely, voluntarily, and intelligently. Any objection to immediate sentencing?
No objection.
No objection, Your Honor.
Thank you, Ms. Donnelly. You can proceed.
Thank you, Your Honor. Ms. Simpson regrets her actions. She was unfortunately did not have the money to pay for everything. She did make everything else was paid for with her bridge card. Time, Your Honor. I don't believe there was I believe that there wasn't any jail time on this. I would just be asking for any discretionary fines to be waived, giving her indigent status. Thank you.
Thank you. Is your client currently employed?
Ms. Simpson, are you working?
No, I get a check on the 1st and the 3rd, Social Security.
Is there a particular, anything that keeps you from being able to be employed, ma'am?
I can work 20 hours. I was diagnosed with CMH for being a paranoid schizophrenic, but I can work 20 hours.
Okay. Okay, I just would advise that if you're going to be able to take care of yourself and be in a position where you don't feel tempted to steal the basic necessities, you might want to try to get some stability and get some part-time employment, ma'am.
Okay, I'm married also.
Okay. And your husband's employed?
Yes, he is.
Okay. Well, I'm going to grant the request of the prosecution. I'm going to sentence you to fines and costs only. There's going to be an amount of restitution owed in the amount of $177.29. There's a $75 crime victim rights fee that will be assessed. That's a $50 state minimum cost that will also be assessed. I'll waive any discretionary fines and costs at this time. When can you make a payment, ma'am?
I can make a payment on the 3rd
How much
to
is
pay
that
it
gonna
off.
be? You're gonna pay everything in full?
Yes, ma'am.
Okay, your total in full is $302.29, okay?
Yes, ma'am.
And I believe the 3rd is a Sunday, so would you?
It'll come out on Friday then.
Well, I'll just put that you'll make payment in full by April 4th. Is that okay?
Yes, ma'am.
Okay. Do you know how to make a payment online?
No, ma'am, I can't come to the court.
You can. You absolutely can come to the court and pay at the window, okay? Do you have any questions at this time?
No, ma'am.
Any additional matters for the record?
Nothing for the people.
No, Your Honor, thank you.
Thank you. You're all set, ma'am.
Thank you.
You're welcome.
Your Honor,
Yes.
On Ladrika Blackman at 9:30, I talked to her wife Lakeisha, and Madrika is at Crisis Services currently. If I could get a couple of weeks adjournment so that I can get in touch with her. They still have the dog, so I'm still expecting we need to proceed and.
April 12th at 9:30.
All right, thank you, Your Honor.
No problem. Okay, sir, you were here on the bond motions. Nobody's appeared. I don't have the files. Both on Kenneth Gavitt and Corey McCullough. Neither of them have appeared. That I don't have the files, but we'll note in there that they failed to appear, so the bond can be released.
Yeah, it's pretty much just coming in to assure you that we were still working on it.
No worries. The bond can be released at this time. They've not appeared for the bond show cost.
Okay, so
He can address you to the counter if you need to deal with them at all. Okay, Mr. Schneider.
Good morning, Your Honor.
Good morning, how are
This
you?
is good. This is, we're here on case number 09-06896, a misdemeanor charge of disorderly conduct from 2007. This is an expungement or a motion to set aside the conviction. My client.
What is the person's name?
Wilfredo Torres Jr.
Okay, is Mr. Wilfredo here?
He is present, and can you take yourself off mute, Mr. Torres? Okay.
Yes, sir. Yes, sir. I'm here, Your Honor.
With the court's permission, he would like an opportunity to address you.
I'll call the case in just a moment.
Is it okay for me to speak?
Not
Not just
at
yet.
this time. I've not called the case yet.
Okay, my
All
apologies.
I've
Your
done
Honor.
is check you in.
My apologies, Your Honor.
No problem. Who is logged in as Zoom user? Can you unmute, sir?
Okay, now I can speak. Thank
What is
you.
your name?
I'm Gene Walter. Gene Webster Walter.
John Walter, or Gene Walter, he's scheduled for 10 a.m. for the pre-trial with Mr. Keaton.
Okay.
At 10 o'clock.
Okay.
Oh, I see him here. Okay, Mr. Keithley, did you need to speak to him?
yes, please, Your Honor.
I'll put you in a private meeting room.
Thank you, Your Honor.
No problem. Let me rename him first. Going from an iPhone, ma'am?
Yes,
What's your name?
Ray Anna Merch.
Do you have an attorney, ma'am?
Sorry?
you represented by counsel?
Yeah, I believe I was.
What is your attorney's name?
It was a public defender, but I don't remember his name.
Denied court-appointed counsel, ma'am.
I'm sorry, say that again?
Our records show that you were denied court-appointed counsel.
That I denied it or that I was denied?
You was denied, so it's likely that you're not indigent. You make too much money.
Okay,
And this is a dog at large and dog licensing, I believe, correct?
correct, yes.
Okay.
Your Honor,
Yes.
I don't know, I think we've been sending out denials into the files, but it's my understanding that she declined a court-appointed attorney at arraignment.
Okay.
No, I did not.
Well, if that's the case, then I'd be happy to take another application.
Okay, well, yeah, we can put you in a private meeting room with someone from legal services. I'm sorry, someone from the public defender's office, and they can do a intake, okay? But give me just a moment so I can make sure she doesn't have another case before I do that, okay?
Okay.
Who's on Caleb's iPhone?
Yes.
The question was, who is on Caleb's iPhone?
That would be me, Caleb.
Caleb, do you have a full name?
Caleb Tuttle.
Your client?
It's Keith, please.
Okay, sounds good. Okay, so I'll put you and Ms. Murch in a private meeting room.
All right, thank you, Your Honor.
Let's see, Ms. Donnelly, you're in room 1, so I'll just add her to room 1.
All right, thank you.
No problem, thank you. Okay, we're on the record in the matter of the people of the state of Michigan versus Wilfredo Torres Jr. File number here, J075515 SM. Council appearance.
Good morning, Your Honor. Andrea Lacey appearing on behalf of the people.
Good morning, Your Honor. Larry Schneider on behalf of the defendant and petitioner.
Today was the day that was set for a hearing on a motion to set aside conviction. I have here an application to set aside conviction MCL under of disorderly person jostling MCL 750.1671L. Date of conviction being November 19, 2007. Not have a opinion from the General's office. Ms. Lacey, did your office receive a copy of this?
Your Honor, I have not received a copy.
I have indicate different charges.
Okay, not for the disorderly jostling.
I have a disorderly conduct and a driving without a license, and then I have
Well, that's what this one's for. Disorderly.
is that okay?
Yep, disorderly disorderly person jostling, disorderly conduct under MCL 750.167 from 2007.
Yeah.
Yes.
The driving without a license is an ordinance violation, so that is scheduled next week with the city attorney's office.
quickly to see if there will be an objection from the prosecution's office.
Sorry, Your Honor. I don't show that we have received any paperwork from the Attorney General's office.
We have not either.
So at this time. I'm trying to find his criminal history to see if he falls in that category, but it's quite a few files too.
Okay.
All right.
Your Honor, just based on a really brief reading of his criminal history, it does appear that he may be eligible, so I would leave it to the court's discretion at this time.
Thank you. Mr. Torres, did you want to make your statement at this time?
Thank you, Your Honor. I just wanted to read a short letter I wrote. And it goes like this. It says, well, greetings to the Honorable Judge Kristen Simmons. My name is Wilfredo Torres, and I was born and raised in the city of Chicago, Illinois. I had a very hard life, born into a poor family with many economic challenges. So as a youth, I fell through the cracks and found myself in gangs and doing desperate things to survive on the streets of Chicago to take care of my mom and my sister, and found myself in a lot of trouble. Excuse me. My apologies.
Take your time.
My mom wanted a better life for us, so she made the decision to relocate us to Lansing, Michigan. And it's true, I did get myself into a lot of trouble with the law here, but I didn't really know any better. You know, growing up on the streets of Chicago, it was tough. Until one time I found myself before the Honorable James Giddings. And he looked at me and he said to me, I can send you to prison, but you don't look like prison material. So I'll tell you what I'm going to do. I'm going to send you to boot camp. And if you don't make it through boot camp, then I'm going to send you to prison. And so I went to boot camp and I learned how to respect people, respect for authority, and many other life skills. And I had a lot of counseling there. And although I got out, I did still have some troubles, but I remembered while in boot camp, they taught me there and told me that I could have a good life with hard work. So I did. And so I did have some troubles after that, but then I ended up getting married in 2002. I had a son in 2003 and worked hard for my family, my wife and children. And I still did have some drinking problems that eventually landed me in sobriety court in front of the Honorable Judge Louise Alderson. And so I had counseling, and I was able to make it through and graduate in 2015. I have a author of my first book. I'm an owner and a manager. Sorry. I'm an owner of a television station. And I minister and counsel many young men and mentor youth. I'm just here to ask for another chance and just to clear up and try to make up for a lot of things that I've done in my past. I'm not the same person I was, and I'm just here today so that I can just make a lot of rounds that I've done right, and just to help as many people as I can. And thank you for your time. And I apologize. I get emotional when I think about it.
No need to apologize. I mean, you're reflecting on some changes that you have been through and your development and your maturity. And those things are reasonably going to cause anyone to become emotional. But I do want to applaud you on the growth and the reflection and making the changes that you needed to make so that you can present yourself here before the court today for the purpose in which you're doing is to try to get some things off of your history and put those things behind you permanently. And so what I know you said you have a radio or a television show?
Well, I in 2002, when I did get out of boot camp, I was helping an old lady run a television station here off Michigan Avenue. It's a Christian television station. It's Channel 19 on Xfinity. And after so many years, she passed away, and she gave me the responsibility of taking it over when I got more responsible. And, ever since I graduated sobriety court in 2015, my life's just changed. And, I made a lot of decisions and got a lot of counseling and a lot of help that really healed me, my inner. On the streets of Chicago growing up, it was real tough. I was in gangs. I witnessed a lot of crazy things out there, but I didn't know any better. So when I came to Lansing, it took me a long time to get past and to see that there was a better life, a better way I could work. And, when I got with my wife, she's just a blessing. And, my life changed then because I don't know, I just learned how to be with somebody to help me. She helps me so much. I can't explain it. So I'm very grateful to God for that and thankful. So I appreciate, everything she does for me.
Well, you sound like a man of good faith. So you understand that he who finds a wife finds a good thing and has favor with the Lord. So I'm thankful that you have found yourself in better positions, that you have a support system, that you're staying out of trouble. That's reflected by your criminal history here. There's not been any interaction with the criminal justice system since the time of your engagement with sobriety court before Judge Alderson. I know she's retired now. She retired a couple months ago, but she would be excited and proud to see you here today for this purpose. And so I do find that the circumstances in your behavior since the date of this conviction does warrant the application to be granted as it is consistent with the public welfare. So I will go ahead and grant your application at this time.
Thank you so much, Your Honor.
Thank you, Your Honor.
Any
Your Honor,
matters? Yes.
Your Honor, I'll be back before you next week. Both of us will be back before you next Monday on the ordinance violation. So if you wanted to wait and simply issue one order and do that next week, that would be fine. Or if you've got an order.
Yeah, I have an order already here.
Okay.
And since it's completed for just this file, so you're all set on that. And there'll be another one tomorrow and next week's file with that information on it, okay?
Okay. Thank you very much, Your Honor.
No problem. Any additional matters for the record?
Nothing further from the defense.
Thank you. You're all set, Mr. Torres.
Thank you, Your Honor, so much.
You're now leaving the meeting. Thank you.
God bless you.
Same to you.
Okay, aye.
Okay. Mr. Keithley,
Yes, Your Honor.
okay, you were in with Mr. Walter, is that correct?
That is correct, Your Honor.
Are you ready on Mr. Walter?
I am, Your Honor.
On the record in the matter of the people of the state of Michigan versus Gene Walter, file number 22-00673, SM, council appearance.
Good morning, Your Honor. Andrea Lacey appearing on behalf of the people.
Good morning, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Mr. Walter, who is present via Zoom.
Thank you. And today was the date that was set for a pre-trial. How are we proceeding on this?
Thank you, Your Honor. An offer was extended for Mr. Walter to plead guilty as charged with no objection to him being sentenced pursuant to 769.4A if he is eligible. I believe he is. However, at this time, Your Honor, we would just be asking that this matter be set for a final pretrial and jury trial.
April 12th at 8 a.m. for the final pretrial. And then May 24th at 8 a.m. for the jury trial.
Final pretrial will be April 12th at 8 o'clock in the morning here in person at the court. Jury trial will be scheduled for May 24th at 8 o'clock in the morning, also here in person at the court. Okay, Mr. Walter? You're muted, but did you have any questions? You have to unmute.
Okay, I'm not mute now. Yes, so the pre-trial is at April 12th.
That's correct, at 8 o'clock in the morning.
Okay, and then there was something else. I didn't quite hear it.
It'll be a jury trial. If you proceed beyond the final pretrial, your trial will be on May 24th at 8 a.m., okay?
Oh, okay, okay. You want
Okay, and we'll mail a notice to you at the Wilson Ave address, okay?
Okay, thank you.
Okay, and both of those court dates will be here in person at the court downtown Lansing. Do you have any
Yes.
questions?
No, you want that.
Any additional matters for the record?
None for the people.
No, Your Honor. Thank you.
Thank you. You're all set, sir.
Thank you.
You're welcome. Okay, Ms. Donnelly, were you able to get the information you needed from Ms. Murch?
Yes, Your Honor. So at this time, I just request that it would be adjourned to the next available date so that we can review the application.
March 29th.
March 29th at 10 a.m. Do you have any questions today, Ms. Murch?
You're muted, but it doesn't see, if you don't, okay. If you don't have problems, you're good.
We'll see you on March 29th.
Okay, thank you.
You're welcome.
Okay, thank you. Am I ready to leave now?
That is correct.
Okay, thank you. Bye.
Thank you.
You have a nice day.
Same to you. Mr. Keithley, do you need to speak privately to Mr. Tuttle?
No, Your Honor. I believe I'm ready to go with Mr. Tuttle.
On the record in the matter of the people of the state of Michigan versus Caleb Tuttle. File number 22-00583 SM, council appearance.
Good morning, Your Honor. Andrea Lacey appearing on behalf of the people.
Good morning, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Caleb Tuttle, who is present via Zoom.
Thank you. Today was the date that was set for a pre-trial. Was there an offer on this?
Your Honor, there is an offer on this. The offer is for Mr. Tuttle to plead to a added count 2 of malicious destruction of property less than $200, contrary to MCL 750-37781D. That is a misdemeanor, punishable by 93 days and or a $500 fine. He asked for restitution in the amount of $234.18, and no contact with the victim throughout pendency of any sentence, as well as the people would dismiss the original count 1 upon successful sentence.
Okay, Mr. Keithley?
Thank you, Your Honor. I've had opportunity to discuss that offer with Mr. Tuttle. At this point, we would be requesting that this matter be set for a final pretrial and jury trial.
April 19th for the final pretrial. April 19th at 8 o'clock in the morning in person in the court will be the final pretrial. April 24th. Sorry, May 24th. May 24th at 8 o'clock in the morning will be the jury trial. Both of them are in person at the court. Any additional matters for the record?
No, Your Honor.
Nothing for the people at this time.
No, Your Honor. Thank you.
Thank you. And Mr. Tuttle, just for the record, your alpha will expire on April 19th, okay?
All right. Thank you.
All right, you're all set.
Thank you.
Can
Take care.
log in, for Ms. Cambridge?
I'm good to leave, right?
You're good to leave, sir.
All right. Thank you. Have a good day.
Same to you. Yeah, Autumn Powell. Ms. Powell, do you have a case number?
21-02. Okay, 21-0232-9 LT.
Okay, well, I know it can't be today because we don't do LT on Tuesdays, but let me see what's going on that case number.
Oh goodness, I hope I didn't put the date in wrong. I put it in my notes. I was supposed to come back.
02329. They dismissed it. Okay, there was a default judgment against you because you didn't appear in court. What day was she supposed to appear? 16th? Yes. You were supposed to be here on the 16th. And you didn't appear, so a default judgment was entered. You need to contact the civil clerk if you want to submit a motion to set aside that default. You need to contact them today.
Okay. Do you have a phone number that I can call?
What's the civil clerk's number?
Or is it this number that's on this? That comes on the court page?
It should be on your paperwork, but let me double check.
Okay,
Does
thank
it end
you.
in 4426?
Yes, ma'am.
Yep, that's the number. You want to call them today or come down to the court today to complete that paperwork, okay, ma'am?
Okay, thank you. I will do that right
You're
now.
welcome. Thank you.
Thank you.
Okay. You're gonna go speak to Ms. King?
Yep.
I see Lindsay Joy here. Ms. Joy, do you have an attorney?
That'd be me, Your Honor.
Okay. Did you need to speak to her privately?
Oh, we've discussed the matter earlier. Ms. Lindsay, did you need have any more questions or want to talk to me before we go on the record?
Yes, please.
Okay, Your Honor, then can I get a breakout room? Or I have room 1, I believe.
I'll add her to room 1.
Thank you.
No problem. And then I see Leanne Barrett. Do you have an attorney, ma'am?
No, I do not.
When the prosecution is available, I'll see if she needs to speak with you privately, okay?
Yeah, okay, yeah, that would be great. Thanks.
No problem. I just did total, so then after that, we're done. We're almost ready for the trial.
Can you hear me?
Yes, we can hear you.
Okay. Good morning.
Morning.
I think my phone is lagging, but I didn't see you talking. And
Morning, person on the iPhone. Your name?
yes, sir. Sherrod Nelson, sir.
Mr. Nelson, do you have an attorney?
Yes, I do. Her name is Miss Sarah Dunley, if I'm pronouncing it right.
Donnelly?
Donnelly, yes, sir.
Just gonna put you on mute for the time being, okay?
Yes, sir. No problem. Thank you. Do I keep it still muted?
Okay. I'm sorry? I'm sorry?
Oh, it's not finished.
Oh, okay. On the record in the matter of the people of the state of Michigan versus Deanna Cambridge, phone number 22-00020 SM, council appearance.
Good morning, Your Honor. Andrea Lacey appearing on behalf of the people.
Thank you. And Ms. Cambridge, you're proceeding without an attorney today.
Correct.
Okay, today was the date that was reset for a pretrial. We were here previously, but prosecution had not received a copy of the ticket. You have a copy at this time?
Yes, Your Honor.
Okay, was there an offer extended?
Your Honor, at this time, I want to extend an offer for Ms. Cambridge to plead guilty to a City of Lansing ordinance violation with regards to the dogs running at large. 610-02. I'm trying to confirm that that's a civil infraction and not a misdemeanor. I don't see it listed as a misdemeanor. So at this time, that would be the offer, as long as it is a civil infraction, she would be able to plead responsible.
What is the ordinance number again?
610-02.
Oh, God, help me, Jesus. That's where we are with the city ordinance. That's 2022. Do not believe that that is a civil infraction.
Okay.
You're looking for just something non-obstructable, is that what's going on?
Yeah. There's not situations of gravity, but there's been multiple instances, so I can't get rid of the case itself, but I'm willing to plead it on to a civil infraction. It really could be anything. I just thought if there was one that was related to animals, it would be appropriate, and we could use that.
Right, yeah, no, it's under the general offenses, but it's not listed specifically as a civil infraction, so it would be under the general offense misdemeanor, but we obviously it could be a civil infraction disorderly or
No.
But I don't know if you want to talk that over with her. Still a civil infraction though. It could be a civil infraction impeding.
You know, Your Honor, just based on her history, or not her history, but her work, I would prefer to be impeding and not anything that appears to be her own personal conduct that is like disorderly in any way. Impeding would be.
Okay. The civil infraction impeding is being offered at 0 points. It's not abstractable. It's punishable with just the court fine of $125. Did you want to take that today, Ms. Cambridge?
Yes, I take responsibility for that.
The fine is $125. You can either make payment online at the court website, or you can come up in person and pay out the window, okay?
Okay.
When do you think you will make the payment?
I'll drive down there in about an hour.
Okay, very good. You're all set. Thank you.
Thank you.
Thank you for that. No problem. Somebody else was representing themselves. Is it Joy, Lindsay Joy? Did you get? No, it's Miss Barrett. Miss Barrett, did you speak to her privately at all?
No.
Okay, Miss Donnelly, you're representing Miss Joy.
Yes, Your Honor.
Are you ready to proceed?
Yes, Your Honor.
We're on the record in the matter of the people of this state of Michigan versus Lindsay Joy, file number 22-00706, council appearance.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, Lindsay Joy, who's appearing separately by Zoom.
Thank you. Today's the date that was set for a pre-trial. How are we proceeded on this?
Your Honor, I have not made an offer for Miss Joy and do not intend to do so unless Miss Donnelly can provide me with some sort of mitigating circumstances for Miss Joy. But at this time, I'm assuming Miss Donnelly wants to set it for a final pretrial and a jury trial.
Is that correct, Miss Donnelly?
Actually, no, Your Honor. I do have some mitigating information, so I will be providing that to her. I was going to request that we adjourn this so that I can talk to Ms. Lacy some more.
We'll set it for a second pre-trial.
We can do the 29th at 10 a.m.
You said that what time? 10 a.m. March 29th at 10 o'clock in the morning, okay? Any additional matters for the record?
Nothing from the people.
Nothing from me, Your Honor.
Okay, thank you, Ms. Joy. You're all set for today.
Thank you, Your Honor.
No problem. Okay, and Mr. Nelson is represented by you, Ms. Donnelly.
Yes, Your Honor.
Okay, are you ready to proceed?
I am, Your Honor, but I do, if I can get a breakout with Mr. Nelson, I need to talk to him before.
Okay, sounds good. And Ms. Lacy, I'll put Ms. Vera in the room with you. On the record in the matter of the people of the state of Michigan versus Leanne Barrett, file numbers 22-00038 and 22-00385. Council appearances.
Good morning, Your Honor. Andrea Lacy, appearing on behalf of the people.
Okay, and Ms. Barrett, you are proceeding without an attorney, correct, ma'am?
That is correct, yes.
Today's the date that was set for pre-trials on two files, both a dog at large and dog license vaccination. How are we proceeding on it?
Your Honor, at this time, I'm gonna dismiss both cases against Ms. Barrett.
You guys have a public address, ladies?
Cases are being-
You guys have a public address?
Cases are being dismissed, Ms. Barrett. You're all set.
Okay, thank you so much. I appreciate it. Have a great day, folks.
Same to you. Okay, Ms. Donnelly, are you ready with Mr. Nelson?
I am, Your Honor.
You are on the record in the matter of the people of the state of Michigan versus Rashad Nelson, file number 22-00655 SM, council appearance.
Good morning, Your Honor. Andrea Lacy, appearing on behalf of the people.
An Assistant Public Defender, Sarah Donnelly, on behalf of defendant Sherrod Nelson, who is appearing separately by Zoom.
No, it's not. I don't see Mr. Nelson.
Yeah, there he is.
Okay. I had to mute you, Mr. Nelson, because you were being disruptive when you were unmuted.
I apologize, Your Honor. I can see you now. My screen went, I'm sorry.
Thank you. Today's the date that was set for a pretrial. How are we proceeding on this?
And I've made an offer to Mr. Nelson, but so I would defer to Ms. Donnelly at this time.
Your Honor, yes, we've received the offer is to plead as charged to the first count of malicious destruction of property between $200 and $1,000 with the agreement to pay restitution. The Ms. Lacy said that the restitution being asked is in excess of $4,500. So at this time, but that would be the offer at this time with the, and if he takes the pleads guilty to count one, they would dismiss count two. Your Honor, we would like time to consider that offer. I would request 2 weeks adjournment to consider pleading to taking the offer. Thank you.
Your Honor, just for the record as well, I don't know if I included it in the email to Ms. Donnelly, so I apologize if I did not,
Yeah.
but there would be, of course, an ongoing no contact order with the victim and the victim's residence, as he does not reside with her.
Like that was, you're right, Your Honor, that was part of the agreement. We discussed that and we also want time to consider that.
April 5th at 9:30. Let's see, separate. That's the plea. Was that it for a plea or another pretrial?
Your Honor, we could set it for a plea on that date.
Okay. I'm gonna set it for an in-person proceeding. Any additional matters for the record?
Nothing further for the people this time.
Your Honor, yes, I was going to make a bond request.
You can proceed.
Thank you, Your Honor. Mr. Nelson informs me that he had a pre-planned engagement to accompany his daughter's field trip to Potter Park. So they would be going from Mount Hope Elementary to Potter Park on Thursday, the 24th. I believe it's until 1 p.m. I think, Mr. Nelson, you said, but you can correct me. And then, but we are asking for that, for him permission to go only because he's on a tether as part of his conditions. And parts of Potter Park Zoo are within 1,500 feet of the Leslie Street address. So I was going to request that he be able to accompany his daughter to that on that field trip to Potter Park So basically allowing him to be within 1,500 feet of where the alleged victim lives, just so long as it's within Potter Park for that day and time.
What was the date and time again?
March 24th, it'll be on Thursday, Your Honor.
March 24th, at what time?
Mr. Nelson?
Yes, Your Honor. Thank you, ma'am. It's only from 9 a.m. until 1, ma'am. I'm just a chaperone, but we're just walking there and coming back. But it's from 9 a.m. until 1, Your Honor, ma'am.
A motion to grant, a motion to allow him to be within the 1,500 feet zone during the time frame from 9 to 1 p.m. on March 24th for the purposes of escorting his daughter to the field trip will be granted. Any additional matters?
Thank you.
Your Honor.
Nothing for the people.
You're all set for today, sir.
Thank you, Judge Simmons.
You're welcome. You're all set. And I think that's all you have, Ms. Donnelly.
It is, Your Honor. Thank you.
Thank you. Have a good one.
You as well.
Trying to get out of